Yes, Shauna.
I don't know many women who wanted to have a kid and didn't want.
Your Honor, before you begin, may the Public Defender's Office be excused?
Yes.
Thank
I was
you.
wondering, I was gonna ask you that, Miss Pleasant. But hey, my job is to call the balls and strikes, not to call to say ball and strike, not to call a pitch.
Okay, thank you. Thank you, Judge.
So everyone from the Public Defender's Office, to the extent that you don't have a case, Mr. Rogers, I think you still have one issue.
Yes, sir, I'm staying down.
Okay.
Oh, never mind, Judge. My apologies, Mr. Rogers. I thought we were finished.
That's okay, it wouldn't be my
All right.
first time being a one-man gang.
Okay, Mr. Ben Hajood, my name is Brad Gardner. I'm going to be the judge presiding over your hearing today. There was, good morning, sir. There was a previous announcement as it relates to the availability of an officer, and your lawyer has an argument to make as it relates to that. Mr. Florio, sir, you can make your argument.
Yes, sir, Judge. So to just a brief factual basis, Your Honor, Mr. Ben Mahoub was arrested on November 3rd of 2021. As he appears before the court today, he has been in custody for 154 days. That is just over 5 months, with no preliminary hearing ever having been had in his case. There was email communication back on March 8th at 1:37 p.m. between myself, the Honorable Court, and Ms. Freeman from the District Attorney's Office, wherein Ms. Freeman identified the officer has been on medical leave, and the officer being Officer Rowe, the arresting officer in this case. The officer has been on medical leave since December 16th of 2022. I believe she meant 2021. His medical leave is scheduled to go through March 18th of 2022. I've given this information to Attorney Florio, which she did. I would ask the case be rescheduled to March 28th to make sure the officer has returned to work. We did not object to that request. This case was calendared for, I believe, on or about March 28th. At that time, the case, the defense was made aware that Officer Rowe was still on medical leave, that Officer Rowe still is not able to appear. When I was approached by Ms. Freeman with regard to that, again, neither myself nor Mr. Ben Mahoub objected to another continuance in this matter to this morning's calendar. But I informed Ms. Freeman at that time that if the officer was not present this morning and not able to appear, obviously I would have to object. I would have to ask for this matter to be dismissed. And Judge, as the court's aware, this is not a normal practice. This is not something I normally engage in. In full candor, I cannot remember the last time that I asked the case be dismissed just because the officer was not available, because I understand oftentimes I'm in the position of asking for a continuance. And I appreciate that the state is willing to oftentimes not object to my request for a continuance. And so I'm always extremely, extremely hesitant to object to a request for a continuance. And for 5 months now, neither myself nor Mr. Ben Mahoub has ever objected. But I find myself in a position this morning, Judge, where I have to object. I have to protect my client's rights. I cannot allow my client to continue to wake up every single morning in the Clayton County Jail for an unspecified period of time. And I respect that the officer's on medical leave. To that extent, Judge, I would ask, has there been anything filed with the Magistrate Court of Clayton County evidencing that this officer continues to be on medical leave? Because I can say it as an officer of the court, I've been presented nothing. And I don't think that Ms. Pitts or Ms. Freeman is lying. And I'm not saying that I believe that Officer Rowe is lying, but there are things that this officer should do if that's the position he takes. If his position is I'm on medical leave, especially in a world where we have Zoom and you can appear virtually from almost any place in the world. If his position is that I'm on medical leave and I cannot appear, then I would at least expect that something would have been filed with the clerk of court, that there would, because we use this term, he's on medical leave. Well, what does that mean? Because that's just a term. To my knowledge, there is no leave that has been filed. And so to say he's on medical leave, that's factually incorrect. He is not on medical leave because he's not filed a leave. Just as I, as a member of the court or a member of the bar, I'm not considered on leave unless I file a leave of absence with the clerk of court. And so to continue to say, well, he's on medical leave, that's just, it's factually incorrect. He is not on medical leave unless there is some document that has been filed with the clerk of court in this matter.
Hold on, Mr. Florio. Let me stop you. Let's break it up a little bit. Lawyers, as officers of the court, we're required to file leaves. I believe the proper way to analyze the fact that an officer, let's say, is out, is whether the court or the state has the ability to call that officer in. And I believe from a labor standpoint, if the person is unavailable, that you can't pierce through that. Let's say the person is on maternity leave. You can't say, well, we have court, so forget the labor part of it, the labor law part of it. We're going to force you to come into court. So I believe it is properly looked through as an employment issue.
So I don't disagree with the court. I think the court's correct. Then to that, I would ask, then what is the issue? Is he on medical leave with the City of Lake City Police Department? Has there been documents filed with the City of Lake City Police Department? I mean,
well, Mr. Florio, I'm going to let you advocate for your client, but as it relates to these issues, that's the sort of threshold, is whether this person is still on medical leave. Because as a judge, I then determine what is fair for both sides, your client with his constitutional rights and the state with their ability to move forward. So I think that's I hear your argument, and that's a threshold issue that I think we can get into a deeper conversation when we first have that question answered. So Ms. Pitts, can you answer that threshold issue?
Your Honor, I have documentation insofar as an email that was had between our office and Anthony Whitmire, who's the chief of police of Lake City Police Department, that states simply that the officer is out on medical leave. So insofar as filing with his agency, it does appear that he has done that.
Okay.
And that's dated March 29th of 2022 at 2:27 p.m.
Which is fine, and I accept both the representations. Now we move to the next issue as it relates to me and trying to filter this out. If the officer was in a situation where, let's say, the officer was deceased or unable to testify, the state will be placed in a position of deciding what they're going to do with the case. They couldn't just leave the case open knowing that they can't move forward. As it relates to this officer, I don't know his medical condition. I don't want to know his medical condition. He has a right to that privacy. But if the officer is not going to be available, then that brings a question as to what is the state going to do? Because I understand, as I see these charges, these are charges that I think can be accused, and the state can accuse this case, move it out of magistrate court, and then the case moves forward. Now, the state would be in a position of having to face other time constraints as it relates to whether they can move forward. And again, I don't know the officer's condition, but if the state is in a position where they know they can't move forward, this person shouldn't stay in magistrate court.
Understood, Your Honor. I do not, the officer in this case is not deceased. We do expect that we will be able to present him. I understand Mr. Florio's frustration. this is the first time that that I've had this file.
Right.
Which doesn't negate the fact that the defendant has been in custody since November of 2021. I looked over, and my office also reached out to see if there was another member of Lake City that would be able to make this out. And we weren't given an opportunity to have anyone for that. I will tell the court that at the time of this incident, the defendant had an outstanding warrant. So in all probability, there should be holes on him.
And I went back. I actually presided over the first appearance hearing. So I went back and looked at the paperwork, and I looked at his criminal history, and he has an extensive criminal history. And so it appeared to me that he was still on probation at the time of this arrest, either probation or parole at the time of this arrest. So this is something where I'm not unsympathetic to your argument, Mr. Florio. Your client shouldn't be sitting here with no action on the case. And that's where I currently stand, that based upon what I've seen and the allegations in this case, your client has not placed himself in an advantageous situation, but that doesn't mean that he gets to be punished without there being a final disposition. So do you know your client's probation status, Mr.
Yes, Judge. There is a probation hold for him out of Superior Court. There was a probation warrant for him at the time that he was arrested. They're for technical violations and this new arrest. And so because he's been in custody now for 5 months on technical violations, I believe that I could resolve the pending the violation of probation in front of the Honorable Judge Malone, absent these criminal charges. But with these criminal charges pending, he finds himself in a position of waiting. I mean, he's been on a probation calendar in front of Judge Malone, and it was continued for the same reason. And so that's part of our frustration is that, I mean, he continues to sit in jail, and I don't doubt that this officer has a medical issue. But I mean, 154 days to have never even had a preliminary hearing, it's a long time. It's a lot of continuances that the state has been given. And I understand he has other issues in front of Judge Malone, and we'll address those issues in front of Judge Malone. But I mean, at some point, if this, the state's had 5 months. I mean,
no, and that's the Ms. Pitts. I'll say that's the frustration that I have, and I know this is not at your feet. This matter can be resolved by drawing an accusation, placing it before Judge Malone, and it comes out of court. Ms. Florio, your client has a probation hold. He has a right to a probation hearing in a reasonable amount of time, but my understanding of reasonableness under the law is not defined. So I do understand 154 days, but this is like, sometimes as a magistrate court judge, I'm sitting here and I'm like, this doesn't even have to be in my hands.
I mean, what I would say is I don't disagree with the court. So this is not a case where there is a victim. So this is not a theft case where either the district attorney's office, or if the state were to deny, if the honorable court were to deny the state's request for an additional continuance in this matter, this is not a matter where there's an identifiable victim in the case, to where this matter is being dismissed to the detriment of someone who's been the victim of a crime, whether it be a property crime, whether it be a theft, whether it be a crime of violence. It's not a case where the district attorney's office is going to have to pick up the phone and call a victim and say, I'm sorry, this burglary case was dismissed this morning, or I'm sorry, Ms. Victim of an aggravated assault, the case was dismissed. Like, there is no victim in this case. The allegation would be drugs and guns in a car during a traffic stop. That would be the allegation. And so we're not in a position where there is a victim that the state would have to answer to. There are other remedies that the state could have availed themselves of over the last 154 days. I guess, in the future, I guess I shouldn't, I try to be as professional as possible, and I try to extend every courtesy to the state that I can. And I feel like at 154 days, if this matter is continued again, then it's a lesson learned for myself. I should have been objecting all along, and I apologize to Mr. Ben Mahoub that I didn't, because obviously the lesson to me is don't be congenial in the future, because after 154 days of being congenial, it gets me looking at him and saying, I'm sorry, sir, but it is what it is. And I don't want to be in that position with him. And I don't want to be that type of lawyer. But
No,
and that's the only reason I've made this request after this long, is at some point I owe it to him. I'm the only person between him and the state of Georgia. And at some point I've got to look at him and at least be able to look this man in his eyes and tell him I'm doing everything I can to fight for him and protect him.
I understand your duty. Your duty is to your client. What I'm going to do. I'm not going to make a decision right now. I want you to file a motion to dismiss Mr. Florio, and I'm gonna take it under advisement, because honestly, I have to do some, I think, some research on this, because it's not coming to mind at the moment, but I know that there are stricter time frames when a case is in magistrate court than after the case is indicted, and they're different time frames. And honestly, I have to look at whether he is entitled to a bond on the charges that do not have a bond, because of the length of time that he's been held without a bond and without a preliminary hearing. And I honestly don't know that answer. So I'm gonna have to look. And I mean, it was just brought to my attention today, this particular issue. So I haven't had an opportunity to go back and look at it, but I've heard your arguments, Mr. Florio, and I've heard from the state. But yes,
I
sir.
apologize, sure. Just for purposes of the record, is the honorable court granting the state's request for a continuance this morning of the hearing scheduled for this morning?
No.
Okay.
That's why I'm asking you to present a dismissal order, because the state presented to the state, and the state can respond. Because Ms. Pitts, the thing, and I don't know, is when is this officer going to come back? So it could be 6 months from now, or it could be 5 days. And I think in order for me to have a better understanding of what is the right thing to do under the Constitution, I have to, I believe, know that information.
Understood, Judge.
Yeah. So right now, I'm gonna have Mr. Florio submit a motion to dismiss, provide a copy to the state so the state can read it and respond. Because right now, where I stand is that if this case is one where this officer is not going to come back for a while because of a medical issue, that's fine, but we just can't keep this case sitting here for that reason. But if this is a situation where the officer is going to be back, then I may have to deny your motion to dismiss Mr. Florio. So what that does in effect will act as a continuance, but at this juncture, I'm leaning towards a dismissal so that the state can do whatever it needs to do. And this case moves out of magistrate court. Okay. All right, Mr. Ben Mahjood, remain in contact with your lawyer. That's going to be the ruling of the court as it relates to this matter. And your lawyer will update you when I issue a decision. Okay. Next case, are we ready for Mr. Tucker, Ms. Pitts?
Yes, Your Honor. Officer Milligan is online.
Okay. Let's see. All right, Mr. Ben Mahjood can go back. Let's bring up Mr. Tucker.
Come on, man. He's good to go. Tucker in 7. Yeah, he's going back. Yeah. They'll grab him, Mr. Tucker, Your Honor.
Okay. Okay, Mr. Tucker, my name is Brad Gardner. I'm going to be the judge presiding over your preliminary hearing today. For the record, this is the case of State of Georgia versus Eric Bernard Tucker Jr. He's charged in warrant number 2022 WA 03879 with committing the offense of battery. He's also charged in warrant number 2022 WA 03880 with committing the offense of false imprisonment. Mr. Tucker is present. He's being represented by Mr. Florio, and Ms. Pitts is here on behalf of the state. Ms. Pitts, you can swear in your witness and begin your examination.
Thank you. Officer Milligan, if you would turn on your camera and take yourself off mute. Thank you. Please raise your right hand. Do you solemnly swear and affirm that the testimony that you will give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
I swear.
Okay, you put your hand down. State your name and your agency, please.
Micah Milligan, police officer with Clayton County Police Department.
How long have you been with Clayton County Police Department?
I'm about to close out my 2nd year.
Okay. And what is your position with the Clayton County Police Department?
Patrolman.
And as a patrolman, would you tell the court what your duties are?
Respond to calls for service. And I mean, that's the bulk of it. There is some proactivity involved, but the easy answer is calls for service.
And are you post-certified?
Yes, ma'am.
On February 25th of 2022, were you working in your official capacity as a police officer with the Clayton County Police Department?
Yes, ma'am.
Did you have an occasion to respond to the incident location of 7828 North Main Street in Jonesboro?
Yes, ma'am.
And is that located within Clayton County?
Yes.
And what was that call for? And tell the court what you did.
We got we were notified that a citizen needed to file a report at our sector watch office, which isn't too far from the alleged incident location. She came to the sector watch office and I spoke with her and she said that there was essentially a domestic incident between her and Mr. Tucker. There was a physical altercation involved where he allegedly wouldn't let her leave. She did have visible injuries. After speaking with her, she said She advised where his most likely location would be, which would be the Woods Motel on North Main. So after doing our investigation, what investigation we could at the time, identified him, learned that he had some warrants, and we went and made contact with him at the North Main location.
Okay, and the individual that made the complaint, was that a Taylor Smith?
Yes, ma'am.
And what was her relation? What did she identify her relationship with Mr. Tucker to be?
I believe they were just dating.
Okay, and you said that she had visible injuries. Were those injuries that you observed?
Yes, her injuries were also photographed to go in with the case file.
Okay, and were they consistent with what she indicated occurred between her and Mr. Tucker?
I believe so. Yes, ma'am.
Okay, and at some point, did you make contact with Mr. Tucker?
Yes.
Okay, and was it at the incident locate? Was it at the location that Ms. Smith indicated was the incident location?
Yes.
Okay, during your investigation, did Ms. Smith indicate to you that at some point she was trying to leave the presence or the place with Mr. Tucker?
Objection leading.
At some point during your investigation, did Ms. Smith? It's a yes or no question, Judge. Not leading.
Well, I was going to say you can rephrase it as to what did he learn as it relates to. I'm sustaining your objection, Mr. Florio, and I'm just asking Ms. Pitts to rephrase the question.
At any point, Officer Milligan, did Ms. Smith make a statement about her ability to leave or not to leave?
Say that one more time. I'm sorry.
At any point during your investigation, did you take warrants out for false imprisonment?
Yes, he was charged with it, utilizing a WAA.
I'm sorry,
He said WAA.
Yes.
A warrantless arrest affidavit.
Right.
Oh, okay. And what were the circumstances surrounding that charge, the false imprisonment?
During the altercation, Smith was saying that she wanted to leave and Mr. Tucker wouldn't let her.
Okay. I have nothing further, Judge.
Mr. Florio?
So let's go back. I understood you to say that you received a call that you were to report to the sector watch office. Is that correct?
That is correct.
And which sector was that, please, sir?
Clayton County PD Sector 4 precinct.
Okay. And who asked you to report to Sector 4? Do you remember?
If I'm not mistaken, one of my supervisors made contact with her first, because at the time we didn't have anybody stationed in our watch office. So I responded and made contact with her at that point.
Okay. And when you made contact with her, that was in person at Sector 4. Is that correct?
That is correct.
Okay. During the course of your investigation, did you ever determine that she had placed a call to 911? Did she call 911?
I don't believe she did. I remember her saying that she went to a friend's room at a separate business, a separate motel, and I believe she called her mother, and then I can't remember if her friend was with her or if her mother was with her, but she did have somebody accompany her. It might have been both of them. And they came to the precinct to report the incident.
Okay. And there was no allegation that Mr. Tucker had taken her phone or damaged her phone or broken her phone or anything of that nature. Is that correct?
I don't recall anything about a phone, no.
Okay. And you'd agree with me, you didn't charge him with any crime related to her personal cell phone. Is that correct?
That is correct.
Okay. At any point, where is it that she said that this incident occurred? What location did she claim this occurred at?
I'm pretty sure it was at the Woods Motel, the 7828 North Main.
Okay, you're pretty sure, or that's where she alleged it occurred?
I'm double checking my report right now. Give me 2 seconds.
Okay, and as you're testifying today, are you reviewing your report?
Just for this question right now.
So Judge, I would object to him using outside materials to refresh his recollection. Obviously, if we were in a courtroom and he wasn't able to answer the question, he could review it. I would have an opportunity to review whatever document it is that he's looking at. I've had this position with Zoom hearing here in Clayton County before, where officers have needed to refresh their recollection. And typically the way it's been handled is that I've been provided a copy of whatever it is that he's reviewing. Just because we're in a virtual setting doesn't mean that I lose the ability to review what it is he's looking at, to cross-examine him with regard to it. And he doesn't, on the flip side, he doesn't have the ability, the legal ability to just read reports during his testimony. Obviously, there's a manner in which that would occur if we were in a courtroom. And just because we're in a virtual setting doesn't mean that we lose, that the rules of evidence are somehow changed.
And Your Honor, insofar as, I'm sorry.
Hold on. So, Mr. Florio, you asked the question. If he doesn't recall, his answer is he doesn't recall. If it's important to you, you can ask him to refresh his recollection. So it's your choice, Mr. Florio. Either he doesn't recall or you give him the opportunity to refresh his recollection.
If he doesn't recall, then I'm okay with that.
Okay. Do you recall, Officer Milligan?
I don't.
Okay. Next question, Mr. Florio.
Okay. I understood you to say that the alleged victim, informed you that Mr. Tucker normally stays at the Woods Motel. Is that correct?
That is correct.
Okay. And at some point, did you go to the Woods Motel to conduct an investigation?
That is correct.
Okay. Did you speak with a leasing office or a manager about whether or not there was a room rented at that motel by Mr. Eric Tucker?
We did. I don't recall if it was under his name or not.
Okay. Did you ask if there was a room rented by the alleged victim, Ms. Kayla Smith?
I don't recall who the room was rented to at all.
Okay. When you got there, did you make contact or did you find Mr. Eric Tucker?
Yes.
Okay. And did you speak with Mr. Eric Tucker?
Yes.
Okay. And what did Mr. Eric Tucker tell you?
So after contact was made, he was advised of his Miranda rights, at which point he decided that he didn't want to speak with me. While I was compiling my paperwork to process through the incident, he began asking me questions, at which point I informed him of why his Miranda rights were being advised to him. He proceeded to agree to speak with me. He told me that there was not a physical altercation, and from my recollection, that was pretty much the gist of it.
Okay. And so while you spoke with Ms. Smith at Sector 4 Watch Office, she relayed to you that certain events had occurred at the Woods Motel. Is that correct? Or had occurred, excuse me. Is that correct?
Yes, that is correct.
Okay. And she told you that Mr. Tucker had put his hands on her. Is that correct?
That is correct.
Okay. Specifically, what did she allege Mr. Tucker had done?
I know she mentioned that he choked her. I don't remember the specifics beyond that of the physical altercation. I just remember that she had visible injuries, I want to say to her arm and her face, if I'm not mistaken.
Okay. Was your body cam working on this day?
Absolutely.
Okay. And it was in good working proper order? It recorded this conversation. Is that correct?
Of course.
Okay. And it's been uploaded to your system, and so it's been preserved for future court hearings. Is that correct?
Yes, sir.
Okay. I also understood you to say that there were pictures taken. Was that correct?
Yes,
And who took those pictures?
I did.
Okay. And were those taken on a county cell phone, or were they taken on some other? What did you use to take the pictures?
It was recorded with my cell phone and uploaded with the case file documents.
Okay. When you relocated to the Woods Motel, were there any witnesses, any independent witnesses that you were able to speak to with regard to this matter?
There was another gentleman on scene. I do not recall him having anything to say pertaining to the incident between Ms. Smith and Mr. Tucker.
Okay, and so there was no one that reported. Judge, my client, there's something he wants to say to me. Obviously, if we were in a courtroom, I could bend down and say, Eric, what is it, son? But we're not because of the virtual setting. May I be placed in a breakout room? I know it delays the hearing, but unfortunately,
I'll get Ms. Florio. You know, you have me at word 1, so you don't have to use word 5. I
Yes,
will
sir.
grant your request